Well, while we're waiting, let me just take this opportunity to tell all of you that I think this is a great competition. This is, I think, my 5th or 6th year doing this. Dawn introduced me. My name is Gary Kramer. I'm one of the 24 district court judges in the 18th Judicial District. And as you probably know by now, the 18th Judicial District is the largest one in the state. We are made up of 4 counties: Arapahoe, Douglas, Elbert, and Lincoln counties. My docket is primarily in Elbert County. I'm the only district court judge in Elbert County. I also do part of the docket in Douglas County. So I kind of go back and forth a lot. And I really like my job a lot. And I don't know if you all know that in 2025, the 18th Judicial District will be splitting into 2. So Arapahoe County is going to stay by itself as the 18th Judicial District, and then Douglas, Elbert, and Lincoln counties will be splitting off, and they will become the 23rd Judicial District. How many of you knew that? January 1, 2025. So there'll be some big changes made then. Most of you back in school, at least part-time now, in school as opposed to just online? Yeah. Well, we've sort of been doing the same thing. We've been mostly shut down for the last year in terms of being in the courtroom. So all of the judicial officers have our own virtual courtroom. We use WebEx, and we each have our own URL to our virtual courtroom. People come in, and we've been conducting all of our court hearings and everything else we've been needing to do through WebEx for the last almost year. And we're just now opening up. I think Arapahoe and Douglas County started their jury trials last week or this week, and I'm starting mine next week. I've got my first jury trials. Well, I had only one in October, November, and then we got shut down again. But we have a lot of criminal trials that we've had backed up that we haven't been able to do in the last year. And starting on Monday, I'm going to be in trial for the next, it looks like 5 months, pretty much straight through, trying to get all those trials done that we haven't been able to do. So this one's fun.
Judge Kramer, I've been informed that we can start.
Excellent. All right. Is Team Kavanaugh prepared to proceed?
Yes, Your Honor.
And what about Team Sotomayor? Is Team Sotomayor prepared to proceed?
Yes, Your Honor. Could we go over some preliminary matters?
We can, counsel. Give me just a moment because I've got a few things that I need to go over with all of you as well. And if I don't cover some of the things that you would like to cover after I'm done, then we can cover the matters that you all would like to cover. So, first question I have is, do either of the teams perceive a conflict, either with me or with any of the scoring panelists?
No, Your Honor, for prosecution.
Not for defense.
No, for the defense, Your Honor.
All
Pardon
right.
me.
Okay. And do I have the team's representations that other than team members, witnesses, and timekeepers, I have no one else who is present in our Zoom this afternoon? Team Kavanaugh
No, Your Honor.
and Team Sotomayor?
No, Your Honor.
Okay. And I need to remind all of you that we are not going to be taking a break today unless there's an emergency. So I just want to make sure everyone's ready to go. Do the timekeepers have any questions?
I do not, Your Honor.
I do not either.
Thank you. Okay, I need to swear everybody in, but so let me do that, and then we can talk about the other preliminary matters. So team members first, please all raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? If so, say I do.
I do.
Thank you. All right, witnesses, please raise your right hands. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions that are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? If so, say I do.
I do.
All right. And now my scoring panelists, if you would please raise your right hands. Scoring panelists, do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition? If so, please say I do.
I do.
I do.
Thank you. All right. Team Kavanaugh, what, if any, preliminary matters would you like to discuss before we begin?
Yes, Your Honor, we have just two. First of all, does the court have a copy of page 4 in the case materials, the stipulations?
The court does have a copy of that. Let me make sure I can find it. I have 4 stipulated facts. The signatures on the witness statements and all other documents are authentic. Chain of custody for evidence is not in dispute. Stipulations cannot be contradicted or challenged. And Exhibit 22 is an accurate copy of a recording from a portion of the court proceedings in the case against Jonathan Rollins.
Thank you, Your Honor. The prosecution moves to have the case stipulations moved into evidence.
Is there an objection from the defense?
No, Your Honor.
That motion is granted. The stipulated facts will be received into evidence.
Thank you, Your Honor. Also, for purposes of efficiently entering exhibits during examinations, we would like opposing counsel to confirm that they have access to all exhibits for this case.
Yes, the defense does have all of the exhibits for this case.
Thank you, Your Honor. We have no more pretrial matters.
Thank you. And for the defense, are there any preliminary matters that you would like to discuss before we begin?
Yes, Your Honor. Permission for the exhibits to be constructively published to the jury only after their admission.
Any objection?
No, Your Honor.
That motion is granted.
Permission for time to be paused should any technical difficulties arise.
Any objection to that motion?
No, Your Honor.
That motion is granted as well.
Your Honor, we also request that all non-participating team members turn off their cameras per the tournament rules in order to minimize bandwidth usage.
Yes, that is part of the rules. I will order that anyone who is not participating, please turn off your cameras. Thank you, counsel. Anything else?
No further preliminary matters, Your Honor.
All right. And one thing that I will tell all counsel is that if you wish to publish by using the Zoom feature to publish, then once I give permission to publish, you may do that without asking for separate permission to do that. Okay. We are now ready for opening statements. The people may present their opening statement now. Thank you. And the timekeepers may begin.
One moment, Your Honor. Your Honor, members of the jury, may it please the court. My name is Kate Megan, and me and my co-counsel represent the people of the state of Colorado in this case. A person is more than their worst mistake, but mistakes have consequences. And the defendant, Avery Becker, must finally face the consequences of her rash decisions that resulted in the death of Mackenzie Brackman. On March 6, 2020, coach of the Colorado High School mock trial team was found dead in his home. He had been stabbed in the back with a knife. As the evidence will prove, he had been stabbed by the defendant, Avery Becker. Today, you will hear evidence from our 3 witnesses demonstrating 3 things to prove the prosecution's claim. First, the evidence incriminates the defendant. Second, there was a deep and thorough investigation carried out. Third, the defense witnesses in this case are unreliable. She has nearly escaped the consequences of her actions caused by her rash decisions. Now she must face the consequences and be found guilty of murdering Mackenzie Brackman. First, you will hear how the evidence incriminates the defendant. The defendant had a feud with Mr. Brackman. That, combined with her rash behavior, has resulted in the break-in of Mackenzie Brackman's house, as well as his murder. You will see ring camera videos and hear how they match the size and build of the person breaking in to that of the defendant. You will see text messages with Alex Fuentes showing her plan to break into the house. You will hear how the school records show that the defendant was absent that day. You will also see evidence of a struggle in Brackman's home and how the murder was not planned, but a consequence of the defendant's mistakes. All of this evidence will show you that the defendant is guilty beyond a reasonable doubt. Secondly, you'll hear a detailed and thorough investigation was carried out. Cusack and Markowitz, our expert witnesses in this case, used their certifications, experience, and expertise to lead a detailed investigation. They were not biased. They simply followed where the evidence led them. You will hear how first Markowitz carefully investigated the scene of the crime, looked into possible suspects, then sorted through physical evidence, cell tower records, ring videos, and more. Then Cusack was needed to write flowcharts, apply crime scene investigation techniques, and find out what really happened. He came to one conclusion. This was a planned burglary gone wrong. There is plenty of evidence to support this. Thirdly, you will hear about how the defense witnesses in this case are unreliable for their opinions. Taylor Perkins has consistently made sacrifices to Avery throughout the course of their friendship. She joined and quit the mock trial team for her. She also skipped school, sacrificing her education to help the defendant look for her phone. And now they're sitting here in court willing to sacrifice things and themselves for the defendant once again. Taylor is only one example of how manipulative Avery is and what she is capable of. Avery has successfully gotten into the brain of Taylor and many others. You will hear the defendant's rash decisions, like vandalizing Brackman's car, and her manipulation skills, like convincing Taylor to quit the team for her, and how she is combining these 2 things to manipulate you in court today. She will claim to be sorry, but with a long-standing feud with Brackman and the anger she has felt towards him, it is simply not believable. You will hear how Van Owen has made it their personal mission to reveal the non-existent mistakes of the police just because of a personal mistake in their past. They will try to convince you that Blair Rollins is a stronger suspect. Van Owen is only dedicated to overlooking the work of the police. Blake Van Owen was so glued to her own agenda that they cannot be seen as credible.
Avery Becker is to blame for this crime. The defense has unreliable witnesses testifying against her. The defendant has a long history of rash behavior, specifically with Mackenzie Brackman. And there was a deep and thorough investigation carried out to display plenty of evidence in support of this. We bear the burden of proof. But members of the jury, at the end of this trial, we will ask you to return a verdict of guilty, convicting Avery Becker of murder in the first degree and burglary in the second degree. It is clear that Avery Becker did commit this crime. Thank you, Your Honor.
Thank you, counsel. All right, is the defense prepared to make its opening statement now, or would the defense like to reserve?
No, the defense is ready now, Your Honor.
Please proceed, counsel.
What makes a good investigation? Is it following up on all possible leads? Is it analyzing the contents of a cell phone? Or maybe it's checking on all possible alibis. Ladies and gentlemen of the jury, today you'll find that the police did not complete any of these tasks in their investigation. A good investigator investigates. They don't take the path of least resistance at the expense of the case. Today, the evidence will show that the police did exactly that. They took the path of least resistance. And now, the defendant, Avery Becker, a girl straight out of high school with a promising future, stands before you today, charged with felony murder and burglary. Her life is on the line today because an incomplete investigation by the police led to a false accusation. Let's begin by talking about the day before the murder happened, March 5th, 2020. That day, Avery Becker and her best friend Taylor Perkins were enjoying a meal at Fry Shack, a restaurant they frequented, when their mock trial teammates stepped through the door. This group included a person named Alex Fuentes, who will be testifying for the prosecution today. Taylor Perkins will testify to the observations she saw between Alex and Avery that evening. The three exchanged some words, and then Avery left for the bathroom, upset. Upon returning, Avery left the restaurant with Taylor. The next morning, Avery discovered that her phone had gone missing, likely being left at the Fry Shack the evening before. So that day, March 6, 2020, Avery and Taylor spent the day retracing their steps, searching for the lost phone. Later that day, they went to the Fry Shack one last time in hopes of finding the lost phone, only to later discover that their mock trial coach, Mackenzie Brackman, had been murdered. Avery Becker is in this courtroom today because the police took the path of least resistance. But today, you'll hear about someone who was never fully investigated by the police. Blair Rowlands. Private investigator Blake Van Owen will testify to her investigation of Blair Rowlands and how she thinks Blair was tied to this case. Blake Van Owen reviewed the police reports, exhibits, and crime scene reconstruction done for this case. She will walk through what she and her expert opinion believe happened to Mackenzie Brackman on March 6, 2020. Today, you'll hear from prosecution witness Detective Markowitz, who will testify that despite her special training with cell phones, she took the path of least resistance and accepted screenshots of text messages as evidence from Alex Fuentes, instead of analyzing the contents of Alex's phone. Detective Markowitz will tell you that talking to Alex was the biggest break in the case. The only physical evidence Alex gave Detective Markowitz were those emailed screenshots. You'll hear from prosecution witness Kyle Kuzak, who will tell you that even though the investigation seemed like a straightforward home invasion crime, he wasn't able to recreate all event segments or place all the evidence. The evidence will show you a picture of an incomplete investigation, one where they didn't follow up on all possible leads, where they didn't analyze the contents of a cell phone, one where they weren't able to place all the evidence, an investigation that follows the path of least resistance. Members of the jury, the prosecution wants you to believe that on March 6, 2020, Avery Becker murdered her mock trial coach, Mackenzie Brackman, who was also a local defense attorney. The defense will present evidence that will show reasonable doubt towards Avery's alleged crimes. The burden of proof, beyond a reasonable doubt, lies on the prosecution's shoulders. Beyond a reasonable doubt is like a line of dominoes. Once one falls, they all tumble down. A doubt is that first domino. One doubt can make the whole case fall. That means that if you, the jury, have even the smallest of doubts about the evidence or testimony presented in today's case, we will ask you to find Avery Becker not guilty. After hearing all the evidence and testimony, you'll find that there is reasonable doubt. It will become evident that the police took the path of least resistance. Mackenzie Brackman's death is a tragedy. This tragedy shouldn't cost Avery Becker's life too.
All right. And are the people prepared to present their case in chief?
Yes, Your Honor.
All right. And so counsel, you may call your first witness.
The prosecution calls Detective Jordan Markowitz to the stand. Good afternoon. Can you please state your name for the court?
Yes, my name is Detective Jordan Markowitz.
Detective, what do you do for a living?
I am a homicide detective with the Denver Police Department.
Do you specialize in any areas of investigation?
Yes, as well as being a homicide detective, I specialize in cell phone technology and forensic data recovery.
How did you receive your qualifications?
I graduated from the American Academy of Law Enforcement, and as well as completing a 3-day training course, I also completed a certification test.
Have you had experience using your training?
Yes, I have downloaded over 100 cell phone data. I have downloaded over 100 cell phones. I have used cell phone tower data on a regular basis, and I've also obtained and interpreted cell tower data in over 50 cases.
Your Honor, the prosecution offers Detective Jordan Markowitz as an expert witness in the fields of cell phone technology, forensic data recovery, and homicide investigation under Rule Code 702.
All right, and tell me again those areas of expert testimony you wish her to testify about.
Yes, of course. The first one is cell phone technology.
Yeah.
The second is forensic data recovery.
Okay.
And the third is homicide investigation.
All right, thank you. And defense, any objection or voir dire?
No, Your Honor.
All right. So Dr. Markowitz will be admitted as an expert and may render opinions in the fields of cell phone technology, forensic data recovery, and homicide investigation.
Thank you, Your Honor. Can you explain how you became involved in the investigation of Mackenzie Brackman's murder?
Yes, I was assigned the case on March 6th, 2020, and I arrived at the scene of the crime at the address 444 South Flower Street at 2:20 p.m.
Can you describe what you saw when you arrived at the scene?
Yes, when I arrived at the scene, I saw the front door open with a deceased white male laying face first in a pool of blood.
I would like to turn your attentions to Exhibits 1, 3, and 5, please. What are these documents?
These are documents of the murder victim and the murder weapon.
Is this a fair and accurate depiction of what you saw at the scene of the crime?
Yes.
Your Honor, I move to have Exhibits 1, 3, and 5 admitted into evidence and published to the jury.
Any objections from the defense to Exhibits 1, 3, or 5?
Yes, Your Honor. I object to to Exhibit 3 being entered into evidence per Rule 401. I don't see how it's relevant when Exhibit 1 is already included and it's unnecessarily gruesome.
Your Honor, permission to respond.
Permission granted, counsel.
I believe that this evidence is extremely important because it shows the actual victim of this crime. And yes, the photos may be gruesome, but we are here to find justice for this terrible murder that has happened to Mr. Brackman. So the evidence is extremely relevant, and you will hear soon when my expert witness testifies to the importance of each one of these pieces of evidence.
Any response by the defense?
Your Honor, I'll amend my objection to Rule 403. Exhibit 3 is cumulative because Exhibit 1, I don't see how Exhibit 3 accomplishes anything that Exhibit 1 cannot accomplish.
Thank you, counsel. And in response to the new objection, the cumulative objection?
Yes, Your Honor. If these exhibits are entered into evidence, my witness will testify why each one of these exhibits is important. I don't want to give away what is in each exhibit, but specifically my witness will testify to certain things shown on the body of the victim.
Thank you, counsel. The court has considered the objection and the arguments of counsel. The court overrules the objections. Exhibits 1, 3, and 5 will be admitted.
Thank you, Your Honor. I will go ahead and screen share these. Can everyone see this image?
No.
No. Detective, would you mind explaining what the screen share is showing right now? Can you not see it?
It says that you have started screen sharing, but it does not show any photo.
Okay. If it's all right, I would like to ask my co-counsel to try screen sharing one of these images.
That's fine.
Thank you. Yes.
Will you allow us one moment, Your Honor, to pull up the exhibit?
Yes.
Ms. Pensino, you said it was exhibits 1 and 3?
Yes, ma'am. Exhibits 1, 5, and 3.
My apologies, Your Honor.
And Your Honor, if for some reason, if my co-counsel, if they are unable to share this documents, would it be okay if we just described in detail what the documents are showing since we're having trouble screen sharing?
You may. Let me just ask the timekeepers, if you have not stopped keeping time, please stop now. And I will add 1 minute if you have not stopped.
Thank you, Your Honor. I'm unable to share it as well for some reason. Ms. Megan, are you able to, or would you just like the witness to describe it?
Well, if you can't screen share the documents,
I
then
have begun sharing these. Can you all see them?
yep, now we can see. All right, timekeepers, you may start again. Thank you.
There is one.
And Miss Megan, would you mind pausing at exhibit 1 for us?
Absolutely.
Thank you.
One moment.
So we are now showing exhibit 1. Detective, what are we looking at here?
Here you can see that the victim is face first in a pool of blood facing his open door. And at the top right corner of the photo, if Miss Megan can scroll up, please, you can see that there is a Ring camera motion detector, that Ring doorbell in the photo as well.
Thank you. And now, Miss Megan, if I could have you show exhibit 3, please. Detective, what are we looking at here?
Here you can see that the wound is placed on the victim's left upper shoulder, and that he is, again, face first in a pool of his own blood.
And finally, Miss Megan will show exhibit 5. Detective, what are we looking at here?
Here you can see the murder weapon. It is covered in blood and it is a stainless steel kitchen knife.
Thank you. And a quick note for Ms. Megan, you might have to start sharing the exhibits for the rest of us. I believe you have a list of those if you'd like to prepare them. Thank you. Now, Detective Markowitz, did you access the data on the Ring cameras?
Yes, I did.
I would like to turn your attention to Exhibit 10, please. Do you have a copy in front of you?
Yes, I do.
What is this video?
This is a video of an intruder walking up to Mackenzie Brackman's front door.
Is this a fair and accurate depiction of what the Ring cameras filmed?
Yes, it is.
Your Honor, I move to have Exhibit 10 admitted into evidence and published to the jury.
Objection from the defense?
No objection, Your Honor.
Thank you. Exhibit 10 is admitted and may be published.
Thank you. Ms. Megan, if you could, would you be able to screen share Exhibit 10 for us? Now, Detective, what are we looking at here?
So as you could see, the intruder is walking up to Mr. Brackman's house to try the front door. You can also see that the intruder is wearing baggy clothing as to obscure the footage from their gender, as well as a mask to obscure the camera from seeing their face. And you can also see that there are gloves, that they're wearing gloves, which is why there were no other fingerprints found at the scene other than Mr. Brackman's.
Thank you. And Detective, what did you do next in your investigation?
Next, after obtaining some of Mr. Brackman's account information, I found out that he was a coach on the Colorado mock trial team, and I reached out to some of their members.
Who did you reach out to?
I reached out to Alex Fuentes.
What did Fuentes tell you?
Fuentes shared with me some screenshots of text messages that her and Avery had texted throughout the days following up to Mr. Brackman's murder, and she sent them through email.
Were you able to interview Avery Becker?
I was not able to interview her for as long as I would like, because once I was able to call Ms. Becker, I was given the phone number of their lawyer that was paid for by her parents, saying that all future communication would then go through the lawyer.
Can you explain what call detail records are?
Yes, so a service provider does not have access to all of the information that a cell tower has access to. So when a phone is called or texted or is just on and not shut off, it communicates with the closest cell tower. And so making it so that someone like me, who has the information of both cell towers and call detail records, it makes it possible to figure out where someone is just by pinging their phone's latest texts or calls, or just pinging their phones from cell towers.
And after analyzing Avery Becker's CDRs, what did you discover?
I discovered that she was receiving many calls and texts from another Colorado mock trial student named Taylor Perkins.
What did you do with the CDR data after discovering it?
I was able to create a sort of map showing her movements on the day of the murder.
I would like to turn your attention to Exhibit 15, please. What is this document?
This is the document that I just talked about, where it is a map of 3 cell towers mapping a common route taken between Becker's house and Mr. Brackman's house.
Is this a fair and accurate depiction of the diagram?
Yes.
Your Honor, I move to have Exhibit 15 admitted into evidence and published to the jury.
Objection?
No objection, Your Honor.
Thank you. Exhibit 15 is admitted and may be published.
Thank you, Your Honor. I will have Ms. Macon share Exhibit 15. Detective, we are now showing Exhibit 15. Can you explain what we're looking at here?
Yes, so from going top to bottom, the first red section is a cell tower that covers Miss Becker's house, and the first half of a street called Rock Creek Parkway, which is a common known route taken from people in this area. The next red section is the next cell tower that is over by the Fry Shack, which was a commonly used hangout for mock trial students, which also covers the second half of Rock Creek Parkway. And the last and final cell tower covers the area of Mr. Brackman's house.
In your expert opinion, what is your final analysis of the evidence?
My final analysis is that Miss Becker left her house around 12:47 p.m. and traveled along Rock Creek Parkway, where she then received another text at 12:55 p.m. from Miss Perkins. She later ended up at Mr. Brackman's house at 1:05 p.m. and was there until 1:17 p.m. where her phone pinged off of this cell tower.
Thank you, Detective, and thank you, Your Honor. No further questions.
Thank you, counsel. Cross-examination.
Yes, Your Honor. Detective Markowitz, let's begin by going over your investigation of the crime scene. You arrived on the scene at 2:20 p.m. on March 6th of 2020, correct?
That is correct.
You noted that the residence was in slight disarray?
That is correct.
Although not enough disarray for you to determine if there was a struggle.
That is correct. Although there were a few broken plates and some scuff marks, I wasn't able to determine the exact amount of disarray.
You weren't able to determine if there was a struggle?
Objection, Your Honor. Asked and answered.
Overruled.
Detective, I just would like a yes or a no to this question. There wasn't enough disarray for you to tell if there was a struggle?
Again, there was only a few broken plates. He could have, in my expert opinion, he could have dropped a plate or left a drawer open. To my knowledge, it wasn't enough to, he could have left a drawer open or knocked a plate off.
Objection, Your Honor. Lack of personal knowledge.
Counsel, Ms. Kite?
Your Honor, this is the witness's testimony. She was choosing to elaborate. I was just hoping to get an answer as to whether she could determine if there was a struggle based on her experience as a homicide investigator. And I think that that's perfectly within her scope to determine whether or not a struggle occurred.
Your Honor, permission to respond.
Permission granted.
These type of questions would be more fit on Kyle Kuzak's testimony, and I would like to keep in mind that this expert has been entered in not as a crime scene investigation reconstruction expert. She's an expert. She has not been entered in as that, and thus these questions are not in her scope of knowledge.
Response?
Your Honor, again, as an expert in homicide investigation, I think that it's perfectly reasonable for this witness to understand whether or not there was a struggle that happened just based on the state of disarray of the kitchen. She's been an investigator for 7 years, or a detective, pardon me.
I agree. This is within the scope of her knowledge and testimony as a homicide investigator. The objection's overruled. You may proceed, counsel.
We'll move on, Detective. You saw the victim's body near the front door.
Yes, that is correct.
You recognized the victim as Mackenzie Brackman?
Yes.
You recognized him because you've been cross-examined by him on several occasions?
Yes, he used to be a defense attorney.
So you were aware that he did criminal defense work?
Yes.
You realize that as a criminal defense attorney, Mr. Brackman might have been targeted by a disgruntled ex-client.
Yes, he might have been.
Now, as a detective, you consider it important to follow up on all possible leads, right?
Yes, that is correct.
Yet, you didn't do any further investigation into potential ties between Mr. Brackman's murder and his career as a defense attorney, did you?
None that I led on in my testimony, no.
In fact, the very first student that you called gave you your biggest break in the case.
I wouldn't say our biggest break in the case, but they gave us a lead, yes.
You're testifying today that this wasn't your biggest break in the case?
I don't believe that a few text messages was what led us to Avery Becker as a suspect. We have many other things to back up our case. This wasn't the biggest thing.
Detective, have you made a previously sworn statement in this case?
Yes.
And in this statement, you signed it, which confirmed that you had carefully reviewed it.
Yes.
You signed it confirming that it was completely true and accurate.
Yes.
And you signed it stating that it included everything and you would update it.
Will you repeat that? Sorry.
You signed it stating that it included everything you knew of.
Yes.
And yet it's still your testimony today that the call with Alex Fuentes and the information that he provided was not your biggest break?
As I stated, it was not our biggest break, but that it will convict Avery Becker.
Your Honor, permission to share this witness's affidavit?
Objection?
No objection, Your Honor.
Permission granted.
Let the record reflect that I am sharing my screen. Detective, is this the sworn statement that you previously made?
Yes.
And is that your signature?
Yes.
Please read along in your head with me as I read out lines 94 to 95. Shockingly, the first student I called gave me the biggest break in the case. Let the record reflect that I have stopped sharing my screen. All right, Detective. That first student you called was Alex Fuentes, correct?
That is correct.
You invited Alex Fuentes in for an interview because he claimed to have received a text message from Avery Becker.
That is correct.
In this interview, you asked to see Mr. Fuentes' phone, but he didn't have it on him.
That is correct. He said that he had left it at home charging.
But Detective, weren't the text messages on Alex Fuentes' phone the reason you called him in the first place?
Well, that and to interview him, yes.
And as a detective, you had never before encountered a teenager that did not bring their phone in with them?
Sorry, will you say that again?
As a detective, you had never before encountered a teenager that did not bring their phone with them?
Never before, but I've never met every single teenager.
Detective, you've learned how to use forensic software such as the Celebrate system to download information from a cell phone, correct?
That is correct.
You use this training constantly as a detective?
As the expert as the specialist in my yes, sorry.
Did you use the Celebrate system to download the text messages off of Alex Fuentes' phone?
I did not lead on in my testimony that I did.
Did you use any other software to download information from Alex Fuentes' phone?
In my testimony, I do not state that, no.
Did you ever ask Mr. Fuentes to bring his phone in later?
No, I did not. I said that emailing the screenshots would be sufficient.
But Mr. Fuentes didn't even send you those screenshots immediately after the interview, did he?
I do not think so, no.
He sent the screenshots to you a day after the interview, correct?
Correct.
And you never verified the authenticity of those screenshots by looking at Alex Fuentes' phone yourself?
That is correct.
Nobody verified the authenticity of those screenshots?
All I can testify is to what I did. I do not know what other people did.
Detective, you never had Alex bring in the phone to the police department, did you?
Not personally, no.
Objection, Your Honor, asked and answered.
Overruled. You may proceed, counsel.
Let's go over some of the other information that you gathered from your investigation, specifically the call detail records. A service provider does not keep all of the information that a cell tower has access to, right?
That is correct.
So you didn't have access to all of the cell tower records, but rather the call detail records.
That is correct.
Call detail records are instances of communication with the cell phone through call or text.
Right, yes.
So they don't show where a phone is at all times, but rather which tower the phone is connecting to when the phone sends or receives a message.
Yes, that is correct.
The call detail records also do not show the content of the message.
No, they do not. They only show the location of the phone at the time that they received or sent the message.
They show which cell tower it was connecting to, right?
Yes.
These call detail records that you obtained showed that Taylor Perkins' cell phone was communicating with Avery's?
Yes.
The records indicate that these calls and texts went unanswered?
Yes.
And you made a diagram, which is Exhibit 15, containing a summary of these records?
Yes, I did.
Your Honor, let the record reflect that I am sharing my screen with Exhibit 15, which has previously been entered. Oh, it looks like my co-counsel is sharing. Detective, you labeled Blair Rowland's residence on this diagram, didn't you?
Yes, I did.
Blair Rowland's residence is within the same area of the specific antenna that Avery Becker's is?
Yes, she was also a mock trial team member. So I labeled, as you can see, there's also Fry Shack and Mr. Brackman's house that I labeled, just to give a better representation.
Detective, you're testifying that Blair Rowlands was a mock trial member?
That's, sorry, I must have misspoke. I apologize.
So Blair Rowlands isn't a mock trial member?
Right, which is why I said I misspoke. I said I apologize for that. I was looking at Colorado High School, and I meant to say that they were at the same high school, not the same mock trial team. I do apologize.
Yet, Detective, knowing that Blair Rowland's residence is in the same antenna area as Avery Becker's house, you still didn't make any efforts to investigate Blair Rowland's?
I do not say so in my testimony, no.
No further questions, Your Honor.
Thank you. Redirect from the people.
Yes, Your Honor, if you'll give me a moment to gather my notes. Detective Markowitz, can you explain how you gathered the screenshots from Alex Fuentes?
Yes, he came in and said that he would have to send me the screenshots at a later time due to his phone being at home charging. I then received an email from him regarding the screenshots.
And can you explain how CDR records are reliable?
Yes, they are reliable because not only do they show where the person is at the time of not only does it show where the person is, but it shows the time that they were sent the message and the call. No matter if the call was picked up or not, it still shows where the person was traveling at that time.
Thank you, Your Honor. No further questions.
Thank you. Are the people prepared to call their next witness?
Yes, Your Honor. We would like to call Alex Fuentes to the stand.
All right. Ms. Fuentes.
Can you please state your name for the court?
Alex Fuentes.
What is your relationship to Avery Becker?
We were on the mock trial team together at Colorado High School, and we were best friends.
How did Avery treat your friends and your teammates?
I did not always appreciate the manner in which Avery treated others on the team.
Would you recognize the defendant?
I would.
Your Honor, could you please instruct everyone in this meeting to turn on their cameras?
All right. Would everyone please turn your cameras on? All right. Go ahead, counsel.
Could you please point out the defendant by describing them and pointing out an article of clothing they are wearing?
The defendant's wearing a black blazer with a white button-up shirt.
Thank you. Your Honor, could you please instruct everyone to turn their cameras back off?
All right. Everyone except Mr. Cifuentes and counsel, please turn your cameras off. Counsel, you may proceed.
Did Avery and Mr. Brackman ever have problems?
Yes, they would argue quite often.
And what did it appear that these problems were about?
Mr. Brackman would constantly tell Avery to prepare better for team, but she refused.
And when did their relationship tip over the edge and go badly?
When Avery was continually late to practice and didn't put it in the work for the team.
Do you know what may have caused your other teammate, Taylor Perkins, to quit the team?
Avery somehow convinced Taylor to...
Objection, speculation.
Counsel,
Your Honor, permission to respond.
please.
This is not speculation because it is based upon the witness's knowledge and how they perceived the situation.
Counsel, why don't you lay a little bit better foundation for how the witness has this knowledge?
All right, so how did you know Taylor Perkins?
We were both on the same mock trial team.
And what was her relationship to Avery Becker?
They were friends.
So would you say that they spoke with each other often?
Yes.
So then do you know what may have caused her to quit the mock trial team?
Yes. Avery convinced Taylor to quit, so then Avery would be bumped back up to the A team for mock trial.
How did Avery appear to feel the day she vandalized her car, Brackman's car?
Angry and frustrated.
And what might have caused her to feel this way?
The way
Objection, lack of personal knowledge.
Permission to respond, Your Honor.
Permission granted.
Mr. Cifuentes here does have knowledge to respond to this because he was in fact in the mock trial practice and meeting that day. So he knows the situation from his own experiences.
Well, counsel, Mr. Cifuentes hasn't established those facts through his testimony, so perhaps you can ask him some foundational questions to establish those facts.
Perfect. I'll establish foundation.
Thank you.
Mr. Cifuentes, were you in the mock trial meeting when Avery stormed out that day?
I was present, yes.
And what was going on in that meeting?
Coach Brackman was mad because Avery didn't prepare much. Avery honestly just went kind of on the fly quite a bit, and that frustrated the coach and others on the team.
And did Avery act this way often?
Yes.
And did Avery appear to feel this way when the day she vandalized Brackman's car?
Yeah, Avery was very angry and frustrated.
Perfect. So then what did you see Avery grab that day as she stormed out of the room?
I specifically saw Avery grab a Sharpie off of the easel of paper we wrote our mock trial ideas on.
And what did Avery do after her vandalizing Brackman's car?
Avery texted me to try to help her get back on the team by trying to convince Coach Brackman.
Would you recognize a copy of these text messages?
I would.
I'd like to turn your attention to Exhibit 14. What is this document?
These are the texts that Avery sent to me after getting kicked off the team.
Is this a fair and accurate depiction of these text messages?
Yes.
Your Honor, I move to have Exhibit 14 admitted into evidence and published to the jury.
Any objection?
Yes, Your Honor. I object per Rule 1002's requirement of an original.
Response, counsel?
There's no response.
right.
I'm sorry. Permission to respond, Your Honor?
Permission granted.
This is an original of this document because I'm saying it is this is evidence collected by the expert witness, and they are the screenshots and the text messages, and they were not edited. And Alex does testify that these are real texts.
Counsel response? Ms. Bednar?
Yes, Your Honor. Even though these were collected by the detective, these are not the original screenshots from the phone. These are duplicates. This is a printout of the screenshots on Alex's phone.
Permission to respond, Your Honor?
Permission granted.
These are the screenshots that Alex sent to the detective, and these are the screenshots that he sent in.
All right. Thank you, counsel. The objection's overruled. Exhibit 14 is admitted.
All right, let the record reflect that I am now sharing my screen. One moment. What is this text conversation about?
This is Avery trying to convince me to talk to Brackman to help get her back.
And how were things going in this text conversation?
I started off by saying, I don't know, Coach Brackman's pretty mad. And the only reason I decided to talk to Coach Brackman was because for the sake of the team, so we could go to our next competition. So that was my reaction.
Perfect. After getting kicked off the team, what did Avery do to you?
Those are the texts that she sent me. That is what she texted me.
And how did Avery react to you telling her Brackman would not let her back on the team?
Avery replied, well, wait till he sees what I do to his house.
Thank you, Your Honor. No further questions.
Thank you. Cross-examination? Ms. Bednar?
Good afternoon, Mr. Fuentes. Let's begin by discussing Avery Becker. You mostly spent time with Avery at mock trial related events, right?
Yes, that is where we got to know each other.
You worked really hard to perfect your skills in mock trial?
Yes, I was very passionate. I worked so hard on my skills in that club.
Avery didn't put as much work into mock trial as you did, right?
Yeah, that's correct. Avery was more on the fly.
Yet Avery was still very successful in mock trial?
Yeah, I mean, I kind of talked about this when I testified originally, but Avery was some scoring panelists and stuff. Sometimes they just naturally like a attorney or whatever better. So unfortunately, even though I put in more work, Avery did sometimes get good recognition.
It upset you when Avery won the Best Attorney Award and the Best Closing Argument Award?
I did think I was more deserving of it.
However, you and Avery were equally skilled in mock trial?
I would say it's close.
Avery's success was a slap in the face, as you put it?
In a way.
It was a slap in the face, correct?
Sure.
Avery leaving the team benefited you, correct?
I guess so. Yes.
Let's talk about what happened after Avery was removed from the team. You saw Avery at the Fry Shack after the night she was kicked off of the team?
Yeah, I saw her.
When you saw Avery at the Fry Shack that night, you had access to her phone, correct?
Yeah, Avery let me play games on her phone.
You also testified that Avery supposedly sent you text messages after she was removed from the team?
Avery did text me.
To clarify, you had played these games on Avery's phone on March 5th, the night before Mr. Brackman's death, right?
If that was the night that after Avery got kicked off the team, then that is correct. I might not recall the exact date. I apologize.
Let's discuss your interview with the police. You didn't bring your phone to the interview?
I was planning on it, so my phone had a horrible battery. My dad called me to go, and it was a simple mistake. I just left it.
You did know the interview was about these texts on your phone, correct?
Objection, Your Honor. Asked and answered.
Overruled. You may answer.
I did know it was about that, but again, it was not a purposeful thing whatsoever, which I've already said. It was a genuine mistake.
Detective Markowitz asked you to send her screenshots of the text messages?
Yes, that is correct. I actually offered to bring the phone after the interview, but the detective did say screenshots would be acceptable.
You went and emailed these screenshots to the detective, correct?
Correct.
You also got rid of the phone containing these alleged text messages?
I turned it in.
You no longer have access to this phone.
I turned it in, so it's not in my possession, correct?
In addition, you don't currently know where the phone is?
Yes, I don't know where it is.
You also didn't initially approach the police when you had received these screenshots?
Yes, I
Objection, relevance.
Relevance, counsel?
Your Honor, this is relevant because when we apply the 401 relevance test, this makes the fact of Alex framing Avery Becker more probable, and this fact is of consequence in, of course, determining who killed Mackenzie Brackman.
Permission to respond, Your Honor.
Permission granted.
Mr. Fuentes has received these text messages prior to the crime, so there is no way of him knowing and that they would need to be turned in prior to this murder happening.
Thank you, counsel. The objection's overruled. You may answer.
Can you repeat the question, please?
Of course. You didn't initially approach the police when you had received these screenshots?
These texts were sent before the murder took place, so not initially, no.
No further questions, Your Honor.
Thank you, counsel. Redirect.
No, Your Honor.
Thank you. All right. Are the people prepared to call another witness?
Yes, Your Honor, the prosecution calls Kyle Kuzak to the stand.
All right. You may proceed.
Thank you, Your Honor. Will you please state your name for the jury?
My name is Kyle Kuzak.
Mr. Kuzak, what is your job?
I am a CSR, also known as a crime scene reconstruction investigator, and I've been certified by the Colorado Bureau of Investigation.
And can you explain what a CSR does?
Yeah, a CSR basically investigates complex crime scenes. For example, I've investigated fatal accidents, homicides, home invasions, burglaries, and the like.
And how long have you been a certified CSR?
19 years.
Do you know why you've been called to testify today?
Yes, I visited the scene of Mackenzie Brackman's death. I've also reviewed all the police reports and exhibits entered for this case.
And can you, oh, I'm sorry. Did you finish the question?
Yes.
Thank you. And can you explain your investigation process?
Yes, so I basically approach the case always assuming that I'm going to reconstruct it later on in the future, especially in court. So from then on, I will memorialize, document, and organize any evidence or any conclusions or theories that I come up for this case.
And did you apply that process to this case?
Yes.
Your Honor, I now move for the admission of Kyle Kuzak as an expert witness in the field of the investigation of crime scene reconstruction, specifically in the areas of home invasions and burglaries, armed robberies, homicides, and fatal accidents, pursuant to Rule 702.
Any objection by the defense?
No, Your Honor.
Thank you. Mr. Cusack would be admitted as an expert in the field of crime scene investigation and may be permitted to render opinions in that line of work. Thank you.
Yes, Your Honor. Mr. Cusack, what did your process lead you to conclude about the case?
The conclusion that I was led to is that on the afternoon of March 6, 2020, a perpetrator of same height and build as Avery Becker was seen trying to enter the front door of Mackenzie Brackman's house. After several entries trying to the front door, the perpetrator enters through the back door. And after that, Mackenzie Brackman becomes aware of the situation and there becomes a struggle between the two individuals, eventually leading to Mackenzie Brackman's death.
And what physical evidence did you find in Mr. Brackman's home?
The back door is adjacent to the kitchen, in which an open knife drawer and a knife block was found. There was also some scuff marks found near the back door, and additionally a broken plate that was near the kitchen table.
And can you tell me more about the knife block?
So the empty slot in this knife block is usually reserved for a large chef's knife, which would actually be consistent with the type of knife that was found in Mr. Brackman's upper back. But it is also important to note that the type of knife found in Mr. Brackman's back was of an alternative, cheaper brand than the other knives found in the knife block.
And how do you know that this knife was from Mr. Brackman's kitchen?
Well, the struggle actually indicates, since it was near the back door, that there was some involvement of the kitchen. Additionally, from the broken plate and scuff marks, I've also deduced that. But additionally, due to the fact that there was an open knife drawer and a knife block with a missing large chef's knife, it also leads me to believe that the knife was there at the scene. Additionally, it seems to me that Mackenzie Brackman was actually the one who took this knife after realizing that there was a perpetrator trying to enter through his back door. I'd also like to make it clear that according to the ring camera videos, it's pretty apparent that the perpetrator isn't carrying a weapon similar to that of a large chef's knife to the house.
And were you able to determine what happened next in the course of events?
Yes, what seems to have happened is that there was a struggle between the perpetrator and the victim, Mackenzie Brackman. They moved from the back door to the kitchen, in which one of them was probably constraining to the other, keeping them in close proximity. However, it seems that the perpetrator was actually able to get an upper hand on Mr. Brackman and eventually take control of the knife and stabbed him in the upper back.
Did you review the autopsy report for this case?
Yes.
And did any of the information in this report have significant relevance to your investigation?
Yes, it actually helped me determine specifically where Mr. Brackman was stabbed and then where he eventually died.
And would you recognize a copy of this autopsy report?
Yes.
Will you please turn your attention to what has been marked as Exhibit 19 in your case materials? And is this a fair and accurate representation of the autopsy report that you reviewed?
Yes.
Your Honor, at this time, the prosecution offers Exhibit 19 into evidence.
Any objection?
Yes, Your Honor, I object to hearsay.
Response?
Your Honor, pursuant to Rules 801D3 and 703, this statement is not hearsay because it is relied upon by an expert and forms the basis of an expert's opinion.
Reply? Ms. Latek?
Your Honor, Rule 801D3 does not exist. Also, Rule 703, as Kyle Cusack can testify to the observations in the coroner's report, it's not necessary to show the coroner's report itself.
All right,
Your Honor, would you like? Oh, I'm sorry.
If you'd like, go ahead and respond. Go ahead.
I can read Rule 801D3 if you would like.
I'm familiar with the rules. All right, the objection's overruled. Exhibit 19 is admitted.
Let the record reflect my co-counsel is screen sharing what has been
Your
entered
Honor,
into evidence as Exhibit 19.
May I
Ms. Latek?
interject?
You may.
In our mock trial rules of evidence, Rule 801D3 doesn't exist. It's only 801D1 and 801D2.
I understand, counsel, but experts are permitted to rely on hearsay in rendering and forming and rendering their opinions. The objection is overruled. Exhibit 19 is admitted.
Thank you. Let the record reflect my co-counsel is screen sharing what has been entered into evidence as Exhibit 19. And Miss Megan, will you please turn to page 3 of the autopsy report? Thank you. Mr. Kuzak, how did the coroner's conclusions aid your investigation?
So if you specifically look to page 3 in the label of cause of death, we can actually determine from the coroner's report what the knife actually did. In this instance, when the knife stabbed the upper back, we can see that it actually nicked the lower arch of Mr. Brackman's aorta and glanced off his pulmonary artery. In this case, with arteries as big as that, you're going to expect a lot of internal bleeding. And in this scenario, at that point, the knife would have actually acted as a partial plug to stop the internal bleeding.
Thank you, Ms. Macon. You can stop screen sharing. What relevance did this have to your investigation, Mr. Kuzak?
Well, it seems to coincide with the blood trail and blood spatter I was able to actually observe in person at the crime scene. What I actually specifically saw was a trail of blood drops leading to the kitchen to near where the front door is, and additionally some cast off blood splatter on the ceiling. This leads me to believe that Mr. Brackman actually took that partial plug out, that knife out, which would have caused a lot of profuse internal bleeding at that moment and actually led to his eventual death. This actually, sorry.
I'm sorry, go ahead.
This actually helps me determine exactly what room Mr. Brackman actually died in and additionally where he was stabbed.
And were you able to recover any DNA or fingerprints from this scene?
Unfortunately, as we can see from the perpetrator, they're wearing a mask and gloves, leading to no any type of fall off from DNA or fingerprints. However, due to these the broken plate, the scuff marks, the knife block, and these blood drops that I was able to observe at the crime scene, this tells me that it was a straightforward planned burglary gone wrong.
And what is your view of Professor Van Owen's methods and knowledge?
I find Van Owen's methods to be quite inaccurate when we talk about cases like these. Van Owen has never been a CSR, he actually only really reinterprets the evidence or the theories that CSR has come up with and then formulates his own opinions on the subject. I feel that I'm actually a lot more qualified than Van Owen in this instance.
And can you elaborate on your refutation of Professor Van Owen's theories about this case?
Yeah. Van Owen seems to believe that Mr. Brackman was actually approached by surprise as he was sitting down. However, this doesn't really add up when you actually acknowledge that there are two major holes in this theory. Firstly, it is actually pretty apparent that Mr. Brackman would have been notified from his Ring camera videos that there was someone at least trying to enter his house or who had approached his house. And secondly, the back door and that sliding open would have created a sound that Brackman would have been able to have heard, notifying him that someone was entering the house at that point.
And are there any other faulty conclusions that Professor Van Owen arrived at?
Yes, specifically when we talk about the whole knife scenario as well, there's another hole in that as well when we actually think about how the knife was held and how the knife was actually stabbed into Mr. Brackman. The knife is held in a very awkward and irregular way, which isn't consistent with any other case that I've reviewed that has similar circumstances such as this, which leads me to believe that this is also inaccurate as well.
And what is your response to Van Owen's theories about the physical evidence?
Well, the thing is, it doesn't seem that Van Owen even acknowledges anything else. In his testimony, he doesn't even really talk about the broken plate or the scuff marks. Instead, it seems to me that all he does is create a conclusion and then choose and pick certain pieces of evidence to fit that conclusion. So I don't find that any of his theories or lack thereof actually add up to anything substantial.
Mr. Kuzak, did your thorough analysis of the crime scene indicate whether or not the murder was planned by the intruder beforehand?
Yes, after carefully examining and looking through every piece of evidence that was provided to me, and from being in person, in location at the crime scene and being able to see what actually happened, I can very clearly formulate that this was a planned burglary gone wrong.
Thank you, Your Honor. No further questions.
Thank you. Cross?
Yes, Your Honor. Before I begin, may I request a time check?
Yes, you do have approximately 6 minutes and 14 seconds left.
Good afternoon, Mr. Kuzak. I just would like to make some things clear. You keep referring to Blake Van Owen as a he, correct?
Yes.
Are you aware that the Blake Van Owen in this courtroom today is a she?
I'm not. I'm very sorry about that. I apologize. I wasn't aware.
Okay, let's move on and talk about the scene of the crime. There was a series of small blood droplets that began near the kitchen table and led to the front door.
Yeah, additionally, there was also cast off blood spatter found on the ceiling. And additionally, I was actually, yeah, as you said, I was actually able to see these.
Thank you, Mr. Kuzak. That will be sufficient. The photos of the blood droplets were corrupted and lost.
Yes, unfortunately they were. However, I was actually able to see these blood splatters in the blood trail that I was talking about.
And as you stated before, there were photos taken of the blood cast off.
Yes.
Those too were corrupted and lost.
Yes, but again, I was able to see them in person. I was able to actually view them.
There are no photos of that evidence for the jury to review today.
Objection, Your Honor, asked and answered.
Overruled. You may answer.
I'm sorry, could you repeat the question, please?
There are no photos of that evidence for the jury to review today.
Yes, unfortunately, but I must stress I was able to actually see these at the crime scene.
Thank you, Mr. Kuzak. No blood splatter or droplets are found in the pictures of Mr. Brackman's dead body.
No.
You would prefer to have more physical evidence at the scene.
Yeah, in a lot of these cases, nothing's ever perfect. I can never assume the best scenario. So again, whether or not it's straightforward or it's the most ideal of cases,
Thank you, Mr. Kuzak.
Sorry.
You couldn't put together exactly what happened?
No, not exactly. I was definitely able to reconstruct a very viable theory in this case, and one that I think is actually true and accurate. But again, there's some instances where I just can't get the full scope of evidence that I need. However, that nowhere near prevents me from actually being able to formulate a significant accurate theory.
You were not able to place all the evidence. A yes or no will suffice.
Sorry, could you repeat the question?
You were not able to place all the evidence?
Could you elaborate on what you mean by place?
Such as recreating all event segments as you, yes.
To a certain extent, yes, but I was able to completely reconstruct exactly how the stabbing occurred and exactly how Mr. Brackman got to where we see him in the other exhibits.
Even with all this evidence, you weren't able to place it, even though the investigation seemed like a straightforward home invasion crime.
Again, I'll stress that, yes, there are some pieces that are missing, but again, given all the evidence that was at hand and additionally from being in person, I was able to reconstruct a really solid—
Mr. Kuzak, I'm not asking you about whether you could reconstruct the crime scene or not. I'm asking you if it seemed like a straightforward home invasion crime. A yes or no will suffice.
Relatively straightforward, but I always, like I said, I always investigate certain things like these with the—
Objection unresponsive.
Mr. Kuzak, if you would just answer the question asked. Thank you, sir.
Yeah, yes, it wasn't relatively straightforward.
Let's move on and talk about your witness tracking spreadsheet. Your Honor, permission for the witness to view Exhibit 17.
Permission granted.
Your Honor, permission to share this exhibit in the screen.
Permission granted. Well, let me ask Ms. Dragovich, is there an objection?
Yes, Your Honor. I fail to see how this is relevant since Mr. Kuzak has already testified about all the information on the spreadsheet.
Your Honor, I'm not entering this exhibit as of right now. I'm setting up foundation to enter this exhibit.
You simply want the witness to view the exhibit. You're not offering it into evidence at this time?
Yes, Your Honor.
All right. The witness may view the exhibit. Exhibit 17, is that what it is?
Yes, Your Honor.
All right.
So, Your Honor, am I allowed to share my screen or should I just refer to the exhibit?
You may share your screen, counsel.
Objection, Your Honor. As we decided in pretrial matters, exhibits that have not been entered will not be screen shared to the jury.
Your Honor, I believe it was a pretrial matter that exhibits are constructively read into evidence, which means that we are allowed to screen share so the witness can see the exhibit, but it's not entered into evidence at that time. So the jury members aren't seeing that evidence.
Well, I'm going to permit the exhibit to be screen shared in this instance. Go ahead, counsel.
You recognize Exhibit 17?
Yes.
Exhibit 17 is a copy of your witness tracking spreadsheet, your physical evidence tracking spreadsheet, as well as the flow chart you used.
Yeah.
You know this because it was used in your first case management step.
Yes.
You regularly use these case management steps in your investigations.
All the time.
You use this to formulate your expert opinion.
Mm-hmm. Yes.
You use this to summarize key points of information from witnesses and suspects.
Yes.
You use this to summarize observations about the evidence.
Yes.
Exhibit 17 is a complete and accurate copy of the witness tracking spreadsheet, the physical evidence tracking sheet, and the flow chart.
Yes.
I move to admit Exhibit 17.
Objection?
No objection, Your Honor.
All right, thank you. Exhibit 17 is admitted.
You use the interview report to summarize the information on your witness tracking spreadsheet.
Yes.
One of those witnesses listed is Taylor Perkins.
Yes.
Taylor provided statements about where she went with Avery on the day preceding and on the day of the homicide.
Yes.
You continually referenced S3 in your summary of information.
Yes.
That person being an unlocated party.
Yes.
That party being Blair Rowlands.
Yes.
But you only listed 2 suspects on your spreadsheet.
Yes.
One of them being Alex Fuentes.
Yes.
No further questions, Your Honor.
Thank you. Redirect.
Yes, Your Honor. Before I do so, may I have a brief time check?
Is the other timer available?
I see it in the chat, Your Honor. Thank you.
All right, thank you.
Mr. Kuzak, are you ever able to fully reconstruct a case to the fullest extent of the word?
No, nothing ever happens to that ideal of a circumstance.
And is that normal for any CSR?
Yes, absolutely.
And are you still able to make valid conclusions?
Yes, of course.
Thank you, Your Honor. No further questions.
Thank you. And do the people have another witness?
No, Your Honor. The prosecution rests.
Thank you very much. And is the defense prepared to proceed?
Yes, Your Honor.
All right, the defense may call its first witness.
The defense calls Avery Becker to the stand. May I proceed, Your Honor?
You may proceed, counsel.
Good afternoon, Ms. Becker. Please state your name and spell your last for the record.
My name is Avery Becker, Becker.
What would you be doing on a normal day in March 2020?
Well, I was a student at Colorado High School, so I would most likely be attending school.
What activities were you involved with at your high school?
Activities I was involved in, I was in mock trial for all 4 years.
How did you feel about being on the mock trial team?
Well, I would say loved it for the most part. I loved the closings, and I especially loved the rebuttals, but my coach and I did not see eye to eye on work ethic.
Let's discuss your relationship with Mr. Brackman. How did you know Mr. Brackman?
Mr. Brackman, he was my mock trial coach for all 4 years.
What types of roles did Mr. Brackman assign to you?
Well, when I was an attorney, I usually got the privilege to do the closings, and when I was a witness, he assigned me the expert roles.
Were there any moments where you and Mr. Brackman disagreed about your skills in mock trial?
Yes, definitely. We saw differently on work ethic. I thought mock trial was more of an art rather than something you should just read verbatim of a script, and Mr. Brackman didn't agree with me. There was an incident after regionals where I got best attorney, and he just kind of went off on me for not following his scripts and saying I was unprepared. I didn't agree with him, and he was just calling me out in front of everyone.
How did Mr. Brackman's criticisms of you during this make you feel?
Mr. Brackman's criticisms made me feel really upset. I mean, who wouldn't, having their coach start lecturing you after you just won a huge accomplishment?
What, if anything, happened to Mr. Brackman's car?
Well, after this regionals incident of us arguing, I got heated and I left the room with what I thought was a dry erase marker, but I later found out it was permanent. I just regret it so bad, and it was just in the heat of the moment.
How did you feel after this incident?
Well, I was devastated with what I have done to Brackman's car. When I realized that the marker was permanent, I was panicking. I was really upset that I did this.
What did you do the following day?
The following day, when I was able to recollect my thoughts, I knew what I had to do. So I went over to Mr. Brackman's office and I asked his secretary if I could speak to him, but she declined. And after that, I just ended up texting him saying I was really sorry, and I would chip off the marker, or I would get a job to get his car repainted.
From your perspective, what was Mr. Brackman's impact on the mock trial team?
Mr. Brackman, although we did not see eye to eye, he was able to get us to a competitive spot in mock trial. We were going to go to state last year, but it just got canceled because of COVID.
How did you feel when you learned of Mr. Brackman's death?
I was devastated. I mean, we never ended up on good terms. I was just upset, I was never going to see my coach again. Even though we didn't have the best relationship, it was just devastating because I wouldn't see him ever again.
To move back a moment, what did Mr. Brackman do in addition to coaching your mock trial team?
Mr. Brackman was a criminal defense attorney.
Were there any associations that you knew of between Brackman and anyone at your school outside of mock trial?
Well, Coach Brackman always tried to help out kids at Colorado High School. He ended up representing Blair Rowlands' dad's case. He lost the case, which made Jonathan Rowlands go to jail.
Let's now discuss March 5th and 6th. Where were you on the evening of March 5th, the day before Mr. Brackman's death?
The day before Mr. Brackman's death, I was at the Fry Shack with my friend Taylor Perkins, and we walked around the mall just doing normal teenage stuff.
Who did you see at the Fry Shack on March 5th?
On March 5th, I saw the mock trial team at the Fry Shack and Alex Fuentes.
What were you doing the morning of March 6th?
Well, I woke up and I was just going to drive over to my friend Taylor's house, but I realized my phone wasn't on me and I realized that it was missing.
When was the last time you remember using your phone before March 6th?
The Fry Shack was the last place I used my phone.
What did you do after you realized that your phone had gone missing?
Well, Taylor and I decided to go looking for it. I wanted my phone back.
Let's move our attention to the screenshotted text conversation that Alex Fuentes had testified to. Did you send any text to Alex Fuentes?
No, I would do no such thing. We weren't close. I didn't like them. And to be quite honest, yeah, I just didn't like them.
Thank you, Your Honor. No further questions.
Thank you. Cross-examination?
Yes, Your Honor. Good evening, Avery Becker. I have a few questions for you. Is it true that one of your motives in joining your high school mock trial team was so that you could have access to your cell phone?
Yeah, I mean, that was a bonus.
And you like to play games on your phone, especially with friends like Taylor Perkins.
I mean, yeah, we're just normal teenagers.
Would you agree that you valued your phone?
Well, I mean, I haven't previously testified to this, but I can now.
Is that a yes or no answer?
Ma'am, I haven't previously testified to this, but I can now if you would like a yes or no.
I would like yes or no answer, please. Yes, you can testify to this.
Okay. Well, even though I liked it and all, I would say no. I mean, it's a phone at the end of the day. I mean, there was some value in it, but to be quite honest, phone's a phone.
Yet you skipped an entire day of school to look for this lost phone.
Well, I mean, yeah, I wanted my phone back, but like I said, it's just materialist things and all our classes are raw. So like, if you want to get your stuff, you usually do it really recently. So it'd probably be there.
So you agree that you would skip school to find something of value?
Well, I mean, I guess you could say that. I mean, my phone is just a phone at the end of the day, but I mean, I wanted it back.
And on the day of Brackman's murder, your phone suddenly disappears.
Yeah, like I said, it just disappeared after the fry shack.
And when you had lost your phone, you didn't realize you had lost it all the way until the next morning?
I mean, yeah, when I got home, I just, did normal stuff. I mean, I didn't really need my phone during this period of time.
Did you respect Mr. Brackman?
I mean, we did have our moments, and we did have our moments, but I think at the end of the day, he did get us to a spot, but.
In fact, you said when speaking about Mr. Brackman that you would tell him, I would tell Mr. Brackman that he wouldn't know a good cross if it hit him over the head.
Like I said, that's one of the things I said in the heat of the moment, but yes, I did say that, but like I said before, he did get us to a competitive spot on the team.
And after a disagreement with Brackman, you retaliated by vandalizing his car.
Like I said, I thought this marker was erasable, but I ended up doing that and I deeply regret it.
And on this car, you wrote Worst Attorney Award.
I believe I wrote Worst Attorney, ma'am.
No, do you remember giving a sworn-in statement before this?
Yes, I do, ma'am.
And do you remember promising to tell the truth and nothing but the truth?
Yes.
I would like to turn and I apologize, do you have a copy of your witness testimony in front of you?
Yes, ma'am.
I would like to turn your attention to page 37 and line 95. If you could, read along silently while I read out aloud. I later learned that it was permanent marker and wrote in giant letters across the hood of the Porsche, Worst Attorney Award. Do you agree that you have misspoken?
Yes, like I said, that was in the heat of the moment. I just tried to forget about it. I apologize dearly. I just remember Worst Attorney, but I won't contradict my statement here.
All right, I understand. And after that, you said you would never do anything else to Brackman.
Can you please repeat that?
Yes, in your testimony, you stated that you would never do anything else to Brackman.
I believe something along those lines, yes.
And if you'd like for reference, it is on page 33 and line 9. However, I don't feel like it's necessary to read along, but in case you need to refresh your memory.
Ma'am, I believe I did say yes to what you just said.
Okay, you seemed unclear on it. I just wanted to make sure. Is it true that Brackman removed you from the mock trial team after your act of vandalism?
Yes, like I said, I really regret that.
And after being removed, you said, in fact, that you would get back at Brackman if it was the last thing you did.
Yes, in the heat of the moment, but I obviously revoked this action because I tried to make up with him and apologize.
Thank you, Your Honor. No further questions.
Thank you, counsel. Redirect.
No redirect, Your Honor.
Thank you. And is the defense prepared to call another witness?
Your Honor, the defense calls Taylor Perkins to the stand.
All right. You may proceed.
Good afternoon, Ms. Perkins. Please state your name and spell your last for the record.
Taylor Perkins, Perkins.
Ms. Perkins, why are you here today?
I'm here today because my best friend is being accused of murder.
How do you know Mackenzie Brackman?
Mackenzie Brackman was the mock trial coach for Colorado High School's mock trial team. I was on the mock trial team when I attended CHS.
Was coaching mock trial Mr. Brackman's only job?
No, everyone knows that Mr. Brackman was also a defense attorney.
Did any of your mock trial teammates ever interact with Coach Brackman while he was fulfilling his role as a defense attorney?
To my knowledge, none of my mock trial teammates ever interacted with Coach Brackman as a defense attorney, but it's pretty obvious that Blair Rowlands did.
Let's talk about Blair Rowlands. How do you know Blair?
Blair Rowlands was one of my peers at Colorado High School.
How did Mr. Brackman know Blair?
It's common knowledge across Colorado High School that Blair had some sort of beef with Mr. Brackman for losing the case that sent his father to prison.
Was Blair Rowlands ever tied to your mock trial case besides Brackman?
Besides Mr. Brackman, so being on the mock trial team, let me just say this, being on the mock trial team, I was able to see a lot of the relationships that my teammates had with other students. Mock trial is a huge time commitment. So yes, I did notice that Blair Rowlands and Alex Fuentes seem to be friends.
Who is Alex Fuentes?
Alex Fuentes is another student on the Colorado High School mock trial team.
Let's move on and talk about Avery Becker and Mackenzie Brackman's relationship. Did they get along?
Speculation.
Response, Your Honor.
Go ahead, counsel.
My witness is only testifying to her personal observations that she had at mock trial practice, as well as being best friends with Avery Becker. It would be in her knowledge to know this and not speculative to talk about things she has observed.
All right, why don't you ask a couple more foundational questions?
You said that how do you know Avery Becker?
Avery Becker is my best friend.
Did you have opportunity to observe things that happened on your mock trial team?
Oh yeah, I was on the mock trial team. I was on A team, so yes, for sure.
Were you able to observe the interactions between Coach Brackman and Avery Becker?
Yep, being on the mock trial team, definitely.
Did they get along?
Coach Brackman and Avery would frequently argue at our practices. And being Avery's best friend and being on the mock trial team, it was pretty clear to me that this feud didn't really go beyond just a difference between what they thought good work ethic should look like in mock trial. I actually found their feud pretty entertaining. It made mock trial somewhat fun. And honestly, I did not care enough to get involved. I just sort of sat back and watched it happen.
From what you've observed, were these interactions ever upsetting to Avery?
Avery would become visibly bothered by some of these reactions, but it didn't bother her enough to do anything more than to just play a few pranks on Coach.
What happened after the regional tournament?
To my knowledge,
lack of foundation.
Overruled. You may answer.
To my knowledge, after the regional tournament, Avery and Mr. Brackman had another one of their disputes about good work ethic in mock trial. So Avery left mock trial practice and she had an expo marker, what she thought was an expo marker. And she even told me that same night that it was an expo marker in her hand. And she wrote something unfortunate on Coach Brackman's car.
What happened to Avery after this?
After this, Avery was visibly remorseful, but Coach still decided to remove her from the mock trial team.
Let's talk about the day before Mr. Brackman died, March 5th, 2020. What were you doing that day?
On March 5th, 2020, Avery had swung by my house And then we went to go grab something to eat at the Fry Shack. And after we left the Fry Shack, we sort of just hung out at the mall.
Who else saw you and Avery at the Fry Shack?
While we were eating at the Fry Shack, we actually ran into most of the mock trial team, including Alex Fuentes.
How did Alex and Avery get along?
Yeah, Alex and Avery did not seem to get along great. Being on the mock trial team and knowing the kind of incredible roles that Avery got, she was talented, it was pretty easy to deduce that Alex had something to gain from Avery not being on the team. From my perspective, it seemed like there was quite a bit of jealousy there.
What were the interactions like between Alex and Avery that evening?
Well, that evening, the entire mock trial team was sympathizing with Avery. You know, she'd just been kicked off the mock trial team, but Alex was going about this pretty passive aggressively.
What happened as a result of this?
As a result, Avery got up and went to the bathroom, and I did see her leave her phone on the table.
What did you do after Avery came back from the bathroom?
After Avery came back from the bathroom, we didn't have any interest in being at the Fry Shack anymore, especially with Alex there. So we just decided to immediately leave. And I didn't think to grab Avery's phone that was still on the table, and I didn't see Avery grab it either.
Let's talk about the day Mr. Brackman was murdered. What were you doing on March 6, 2020?
On March 6th, 2020, Avery and I were looking for her phone that she had lost the previous night.
How did you know Avery's phone was missing?
So Avery usually took me to school every morning. And the morning of March 6th, 2020 wasn't any different, except I had texted Avery and she didn't respond. So when Avery came to pick me up to go to school, I sort of jokingly mentioned that, you know, she had responded to my text, and that's when she realized she didn't have her phone on her.
Is it normal for you two to text often?
Oh yeah, I mean, Avery's my best friend.
How did you go about finding Avery's phone?
Well, we retraced our steps from the previous day, meaning we went to the Fry Shack and we'd gone to the mall after the Fry Shack. So we looked there, and the entire time I was calling Avery's phone and texting it in hopes that maybe it would make some sort of noise or someone would pick up.
Who else saw you and Avery together the day Coach Brackman was murdered?
Well, so we had gone to the mall, and then we went to the Fry Shack where we checked in with the
Objection, Your Honor, non-responsive.
Response, counsel?
Your Honor, my witness is responding to the question to her full extent and what she knows.
Permission to respond, Your Honor.
Permission granted.
You asked your witness who had seen them at the day of Brackman's murder. That is not the question she is answering currently.
Your Honor, if I may.
Why don't you re-ask the question, counsel?
Who else saw you Who else saw you and Avery together the day Coach Brackman was murdered?
Well, like I was just talking about, to rephrase, we were in the public, and then we went to the Fry Shack where we checked with the afternoon shift staff, and we actually ran into some members from the mock trial team at Fry Shack again. They had left practice early because Coach Brackman hadn't shown up, and like the rest of them, we later found out that Coach Brackman had passed away.
No further questions, Your Honor.
Thank you. Cross?
Yes, Your Honor. You are friends with Avery, correct?
Yeah, Avery and I are friends.
You were on the mock trial team together, correct?
That's right.
And Mackenzie Brackman was your coach?
Yep.
You observed a feud between Avery and Coach Brackman.
I did observe a feud, but like I said, it didn't really seem to go beyond anything more than just a difference between what they thought good work ethic looked like in mock trial.
And did Avery seem bothered by this?
Yeah, sure. Avery would become bothered, but never enough to do anything more than play some pranks on Coach Brackman, which, again, I actually found pretty entertaining.
Would you say Avery was often unprepared?
Yeah, Avery was unprepared, but she didn't really seem to need to be prepared. She was incredibly talented at speaking impromptu and coming up with closing arguments and crosses on the spot.
And it was her unpreparedness that caused her to be demoted to the B team?
Yeah, sure. Coach Brackman definitely would have disagreed with me there.
You did leave the team for Avery, correct?
I did leave the team for Avery. After Avery was kicked off of A team, I had no interest in being on A team anymore, especially when I didn't have friends around. I only joined mock trial because, Avery was in mock trial. I didn't even want to be a lawyer.
You believe Avery vandalized Brackman's car because she needed to let off steam, correct?
Sure, yeah.
You also believe that she wanted to freak Brackman out?
Yeah, I mean, heat of the moment. To my knowledge, Mr. Brackman had said some pretty hurtful things.
After getting completely kicked off the team, Avery did text Alex Fuentes about getting back on the team, correct?
Objection, lack of personal knowledge.
Permission to respond, Your Honor?
Please.
Taylor, being Avery's best friend, would know about these messages because Avery would have told her about them.
Counsel, why don't you ask a couple of more foundational questions?
All right. You interacted with Alex Fuentes often, correct?
Sure, yeah. Alex was on the mock trial team. We weren't really friends or anything.
And you and Avery were together I'm sorry, Your Honor. May I move on?
You may.
Avery attempted to get back onto the mock trial team, correct?
Sure, yeah. I mean, mock trial meant a lot to Avery.
And she was unsuccessful in these attempts?
Yeah, it didn't really seem like Mr. Brackman wanted to budge.
You can confirm that Avery was not at school Friday, March 6th of 2020, correct?
Oh, absolutely, because I was with her.
A yes or no answer will suffice.
Yes, I can confirm that.
Thank you, Your Honor. No further questions.
Thank you, counsel. Redirect. Redirect.
Briefly, Your Honor. Ms. Perkins, how do you know Avery Becker didn't kill Mackenzie Brackman?
Well, I know that Avery didn't kill Mr. Brackman because I was with her for the entirety of March 6th, 2020.
Who else saw you that day?
Well, like I said, we were in public places and then we went to the fry shack where we...
Objection, Your Honor. There is no one testifies to that.
Your Honor, if I may.
Counsel, you may.
It is in Ms. Perkins' witness statement on where she goes that day and who she talks to on March 6th. I can point out specific line numbers if opposing counsel would like.
That is not necessary.
All right. You may answer.
Would you like me to re-ask the question?
Yes, thank you.
Who else saw you together with Avery that day?
Like I said, we were in public places and then we went to the fry shack and we checked with the afternoon shift staff for Avery's phone and we ran into other students from the mock trial team.
No further questions, Your Honor.
Thank you. And does the defense have any other witnesses?
Yes, Your Honor. The defense calls Professor Blake Van Owen to the stand.
All right. Professor Van Owen. Counsel, you may proceed.
Before I begin,
go ahead.
Pardon me, Your Honor. Before I begin, may I have a time check?
Timekeepers, please.
1 moment, Your Honor.
Thank you.
May I proceed, Your Honor?
You may, counsel.
Good afternoon. Please state your name, spelling your last for the record.
My name is Professor Blake Van Owen, Vanowen.
What do you do for a living?
Well, I'm a private investigator, professor, and I frequently testify as an expert witness in police practices.
What experience do you have with police practices?
Well, all of my experience began back when I was part of the Aurora Police Department.
And what police practices, specifically from your time on the Aurora Police Department, do you have experience with?
Well, I have experience with use of force, forensic evidence techniques, false arrests, crime scene reconstruction, cell tower analysis, and general police practices.
You said that you're a professor alongside being a private investigator. What do you teach?
Well, I teach social justice and police practices at CU Denver.
And what education do you have related to police practices?
Objection, Your Honor, leading question.
That's not a leading question. Objection's overruled.
Could you explain your education for us?
Yes. So I have my degree, a master's degree from Ashford University's online program. This degree is in criminal justice.
How much experience do you have working as a private investigator?
I have a ton of experience. I've consulted on more than 100 cases. I've testified 5 times as an expert in cell tower analysis, 8 times as an expert in crime scene reconstruction investigation, and 12 times in general police practices.
Your Honor, at this time I move to tender Professor Blake Van Owen as an expert in police practices, crime scene reconstruction, and cell tower analysis.
Any objection?
Yes, Your Honor. Permission to conduct a brief voir dire.
Permission granted, counsel.
Professor, in your statement for this case, you included everything that you know of to be relevant to this case, correct?
Yes, I did.
And nowhere in this statement do you mention ever being a certified CSR, do you?
No, I didn't feel like it was relevant. I think my times that I've
for this, thank you, Professor.
Testified is well enough, as well as
Professor Van Owen, with all due respect, is that a no for this question?
Could you repeat the question?
Nowhere in your statement do you mention ever being a certified CSR, do you? Yes or no?
No, it wasn't relevant. I had enough evidence.
And the class that you teach is about police practices and social justice, correct?
Yes.
And you have a degree in criminal justice?
Yes, I do.
And nowhere in your statement do you mention having a degree in criminology, do you?
No,
Yes.
I do not believe that I do.
Nor do you mention having a degree in any kind of forensic science, do you?
No.
Your Honor, the prosecution objects to Professor Van Owen being entered as an expert in the field of crime scene reconstruction due to a lack of education and experience in this area.
Thank you. Ms. Kite, response?
Yes, Your Honor. Per Rule 702, it's only necessary for a witness that's being entered as an expert to show expertise by knowledge, skill, experience, training, or education. And as Professor Van Owen testified, she has experience with crime scene reconstruction from her work on the Aurora Police Department. She does not need to have all 5, and she testified as to having the experience.
Thank you. All right, counsel, thank you for your argument. The court will admit Professor Van Owen as an expert in police practice, crime scene reconstruction, and cell tower analysis, and will permit her to render opinions in those areas. You may proceed, counsel.
Professor, let's begin by talking about the theory that Detective Markowitz and Mr. Kuzak discussed. Is this a theory that you agree with?
No, not at all. The only thing that we can agree on is that someone broke into the house.
So did you find any issues with the police investigative methods?
Yes, the first and most glaring issue that must be addressed is that the police never looked into Avery Becker's alibi. something that's very important to look into, especially when you're impaneling a jury.
In what ways, in your opinion, should the police have looked into Avery Becker's alibi?
Well, there are two ways. One, they should have looked into where Avery Becker's phone was the day before the murder, as well as they should have looked into Taylor Perkins' phone records the day of the murder.
Professor Van Owen, did you review the cell tower data that was gathered for this case?
Yes, I did. I reviewed the cell tower data as well as all of the exhibits that Detective Markowitz has and Kyle Kuzak's crime scene reconstruction investigation reports.
What does that cell tower data reveal to you?
Well, it reveals nothing other than the phone interacted with that cell tower at a certain time. It's not anything like GPS data, which is what the police are trying to use it as.
Does the cell tower data tell us where the phone is before the murder?
No, it does not, because again, Markowitz did not look into Avery Becker's alibi. They simply subpoenaed the phone records from the day of the murder and didn't even bother to look into the phone records the day before. Again, they were extremely rushed.
You mentioned that cell tower data is not like GPS data. Could you please elaborate on what you mean by that?
Yes, cell towers are not specific at all. So in a rural area, cell towers can span a reach of 100 miles. In an urban area, they can have a radius of 6 to 7 miles. That gives them a diameter of 12 to 14 miles. That's pretty large. And then when you put on top of that these cell towers can overlap, it gives you a very unclear area where a phone is at looking at the cell tower records, as well as you can be at a cell tower. You could be right next to a cell tower that's a mile away, and connect to one that's 6 miles away.
Let's move on to the investigation of the crime scene and the physical evidence. Did you find any issues there?
Yes, I did. There were a ton of glaring issues. There were issues with the blood splatter evidence, the scuff marks, the ring security videos, as well as the origin of the knife and the way that the knife was used in the murder. There are also issues with the screenshot specifically from the phone. The police have a Celebrite system that they could have easily run the phone through and gotten all of its contents very quickly.
So let's go through that in a list. You mentioned issues with blood splatters. What were those?
Well, the issues is that the evidence got lost. Normally, this would be kind of something that clued you into possibly something dubious going on, but in this case, it's just incompetence from a rushed investigation.
Next, let's talk about the scuff marks. How did your opinion on the scuff marks vary from the one that Kyle Kuzak drew?
Well, Kyle Kuzak believes that these scuff marks came from a struggle, an altercation between Mr. Brackman and an intruder. The issue with this is that we cannot say certainly when these scuff marks were ever made.
Let's discuss the ring security footage. What were the issues that you found there?
Well, there are three. One, there's an issue of assuming that Kyle Kuzak assuming that Brackman got the ring security notifications, meaning that the ring security notifications were on. Two, there's an issue where Kyle Kuzak assumes that Brackman had his phone on him at the time of the crime. As well as three, there's an assumption that Brackman even acted on, if he even got alerted, ever acted on being alerted to this to go and confront the intruder.
Next, let's talk about those several different issues with the knife that you found. What were those?
Well, to begin, Kuzak made two assumptions. One, an assumption of where the knife was from, and two, an assumption of how the knife was used.
And what were those assumptions?
Well, the assumption of where the knife was from is that Kuzak saw a knife block with a missing slot in it and immediately assumed that this knife was from this knife block, when the knife does not have any of the same, it doesn't match any of the other knives at all. So there's nothing tying it back to the knife block, at least nothing 100% tying it back.
Did you do any investigation into alternate suspects?
Yes, I did. So I looked into someone named Alex Fuentes. Alex Fuentes had a lot of connections to this case. My apologies, I looked into Blair Rowlands. pretty much Blair Rowlands was friends with Alex Fuentes. There were other issues where Blair Rowlands was connected to the case. Blair Rowlands had a rocky past with Brackman because Brackman defended his father and lost the case, as well as Blair Rowlands went to Colorado High School and was missing from school the day of the murder.
You mentioned this case. Were you able to view the case where Mr. Brackman lost?
Yes, I was. I went through all the court proceedings.
Was Blair Rowlands present at their father's trial?
Yes, they testified for their father at the trial, so they were there when their father was convicted.
What is Exhibit 22?
Well, it's an audio recording of a statement that Blair Rowlands' father's made. Not even so much a statement, just him yelling at Brackman after he was convicted of murder.
Your Honor, at this time I move to enter Exhibit 22 into evidence.
Any objection?
Yes, Your Honor, while there's no doubt that this is from the actual trial, according to the stipulations, I still object to this as being hearsay.
Response?
Your Honor, per the definition of hearsay in Rule 801C, this is not hearsay, since as the professor was testifying, this linked Blair Rowlands to Mr. Brackman and had an influence on the motive. So this is not being used for the truth of the matter asserted, but rather the effect on the listener. And additionally, if the court did find that it was hearsay, it would fall under exceptions 8032 and 8033.
Thank you. Ms. Dragovich, response?
Yes, Your Honor, as we just ask that the jury, as they're listening to this recording, do not take this as for the truth of the matter asserted, but as simply a comment made by Mr. Rowlands.
Thank you. Exhibit 22 is admitted.
Your Honor, permission for my co-counsel to share their screen and play the audio.
Permission granted.
I'll get you back, Brackman, if it's the last thing I do.
Let the record reflect my co-counsel has stopped sharing their screen. Professor, what was the significance of that recording to your investigation?
Well, the significance is it shows a large motive that Blair Rowlands would have to commit.
Your Honor, hearsay.
I'm sorry. There's an objection. Go ahead, Ms. Dragovich.
Yes, I was just about to say we agreed that this would not be offered for the truth of the matter asserted, and now Professor Van Owen is saying that this proves motive on Mr. Rowlands' part.
Counsel, response?
Your Honor, again, the statement was being used for the effect on the listener, with the listener being Blair Rowlands, who, as the professor testified, was present in the court. And this is of most importance since Blair Rowlands is an alternate suspect. And the case of the motive is unrelated to the statement itself, and that is what the effect on the listener was.
All right, the objection is overruled. The witness may answer the question.
Go ahead, Professor.
Well, as Blair Rowlands was obviously on their father's side since they testified for him, it makes sense that their father's sentiment would definitely affect them, especially in such a way where their father's being put away for life. It's extremely traumatizing and has a huge effect on, would have a huge effect on Blair Rowlands, and I think would cause a lot of bad blood between Blair Rowlands and Mr. Brackman.
No further questions, Your Honor.
Thank you. Cross?
Yes, Your Honor. May I have a time check before I begin? Thank you. Professor Van Owen, you said that you disagree with the police's investigation methods, correct?
Yes, in every way possible.
And you said that you, quote, make a decent living revealing where the police have dropped the ball.
Yeah,
and you
I mean,
a
just like, well, could I say why I said this? Because I think this would...
I believe your answer was sufficient. Thank you. We'll move on. You consider yourself a check on the power of police.
Yeah, someone has to stick up for the little man.
So it's your job to criticize the department's techniques, the police department?
I am a private investigator.
So you have made it your job to criticize the police department's techniques? Yes or no?
It's not so much my job to criticize, it's my job to make sure that people who are being charged also have professionals who are competent, helping them defend themselves. That's my job.
For this case, it is your job to criticize the police department's techniques.
Well, if I have to criticize them to defend
yes?
someone, yes.
Thank you. During your very brief time as a cop, you injured a young woman during an arrest, didn't you?
Well,
Objection, Your Honor. Rule 401.
Relevance objection, counsel, relevance.
Your Honor, Professor Van Owen's experience as a cop reveals a bias that affected her investigation and critique of the police department's techniques, and therefore is very relevant to this case.
May I respond, Your Honor?
You may.
The defense has several issues with the admissibility of this fact or this evidence, and if the court finds that it is indeed relevant, it is far more prejudicial than it is probative, because the prejudice outweighs any probative value that it might have. And additionally, this is improper character evidence. This evidence cannot be used to show that professor, because she was kicked off of the police force or removed from it unfavorably, that she would act in accordance with any bias that might have formed.
Would you like me to respond to that, Your Honor?
I would, counsel. Thank you.
Your Honor, I am not trying to say that Professor Van Owen is guilty of any wrongdoings. I'm sure that she was about to testify. She was cleared for this. However, the effect that this incident had on her was very significant, as you will hear, and directed her next steps in her life, which are relevant to this case as she is talking about the police department.
All right. Thank you, counsel. The objection is overruled. The witness may answer.
Thank you, Your Honor. So I'm sorry, did you have a chance? Did you answer my question, Professor?
No, I didn't get a chance to answer it.
All right. So during, I'm sorry, during your very brief time as a cop, you injured a young woman during an arrest?
Yeah, and it was one of the greatest mistakes in my life.
And you ended up leaving the department because of this?
Yeah, the fact that I was officially cleared of wrongdoing because this was allowed, after seeing the effect of it on the woman, it was kind of, I just couldn't stay there morally anymore.
And you have never forgiven yourself for this mistake?
Yeah, this is part of why I do my job the way that I do it. Someone has to stick up for people like that woman.
You carry that guilt with you?
Yeah.
And you will earn a relatively large amount of money for testifying against the police today?
I mean, it's not a huge amount, but professor, and that's not a lot of money. I mean, just like investigators make money to investigate, I make money doing this.
Up to $10,000 just for showing up to court today alone?
Yes.
You've only ever testified as a defense witness, despite any reasoning for that?
Well, there is reasoning. Prosecution only has witnesses who are police officers or work for the police, and that's because they don't have to pay them. So, one, I do this because I feel like it's my responsibility.
Is that a yes to my question, ma'am?
Well, yes, I do that for these reasons.
Thank you. And in your statement, you said that you think Kyle Cusack is egotistical.
Yes.
And you said that most people hold a knife in the way that Cusack explained.
Yes, I said that, but what's important is the way that the knife's shaped. Just saying because most people do it doesn't prove that it was held a certain way. It makes more sense for the knife to be held the way that it was because
most
it's more comfortable.
Hold it in the way that Kyle Cusack explained, yes or no?
Yes.
In your statement, you said that what makes Cusack's theory unlikely is the height difference between the intruder and Mr. There's no evidence that the Ring camera notifications were turned off, isn't that right?
Yes, because Detective Markowitz never looked into the Ring security notifications. I don't have the ability to do that because I cannot take Brackman's phone. That was Markowitz's responsibility, not my own.
You said that cell towers do not reliably or accurately prove location.
Yes.
Furthermore, the cell towers only record what towers a person's phone connects to, obviously not the person herself.
Yes.
You criticized Detective Markowitz for not collecting enough of these cell tower records.
Yes, I do.
And you said that the missing photos of the blood drops could not have helped find the killer of Mackenzie Brackman.
No, they could not have. The fact that they're missing is just an issue with how the police are running things.
In your statement, you mentioned no evidence for Blair Rollins not being in Colorado except for a feeling that you have.
Yes. I mean, I couldn't even find where Blair Rollins was even after I exhausted all of my resources. So it's not like I could find any evidence. I'm sure, though, with the police, with all the resources that they had, if they actually tried to, they could find Blair Rollins.
Thank you. I believe you answered my question well. And you also said that Blair Rollins could have stolen the defendant's phone and driven to Mr. Brackman's house.
Yes, that is very likely.
And your evidence for this is the cell tower records?
Well, if we're going to trust the cell tower records and use it the way that the police have them, yes. If we're going to trust them, this is perfectly likely.
It's your testimony that we should not trust these cell tower records, isn't it?
I never said that's my test. Well,
you called them inaccurate and unreliable for proving location?
Yes.
And moreover, the route Blair Rollins would have had to take in order to align with your theory is an unusual and unlikely route, isn't it?
That's true. It is a route that I wouldn't have thought, but it does go straight through those towers.
You also mentioned no evidence in your statement for Fuentes creating fake text messages, except that the police accepted screenshots, correct?
Well, the evidence is that we cannot verify these text messages other than Fuentes'
Because you believe the police should not have accepted the screenshots, you then assumed that Fuentes faked the messages?
Could you repeat that?
Because you believe that the police should not have accepted screenshots, that led you to automatically assume that Fuentes faked the text messages.
It's not an assumption, it's that it is a likely possibility. And since that's a likely possibility, that's an issue.
But you don't mention any evidence in your statement besides the fact that the police accepted screenshots.
Well, the evidence is that they are screenshots.
Yes or no will be all right. Do you mention any other evidence?
No.
And you also said you have no way to prove the scuff marks on Mackenzie Brackman's floor were there before March 6th, 2020?
Yes.
And besides a vague comment made by Blair's father, you don't mention any evidence in your statement that solidly implicates Blair Rollins at the crime scene more than it does the defendant.
Actually, I do. I stated that Blair Rollins was missing from school the day of the murder.
I'll repeat my question, or I'm sorry, I'll rephrase it. The only concrete evidence that you mention in your statement is the fact that Rollins and the defendant are the same build?
Well, I believe Blair being gone from the school that day as well is concrete evidence.
Did you suspect Taylor Perkins for being gone at school? You did not, did you?
Well, no, because Taylor Perkins was with Avery Becker.
Thank you. And I'm sorry, so I will re-ask the question. I believe there's still some confusion. You don't mention any evidence in your statement that solidly implicates Blair Rollins at the crime scene more than it does the defendant. Not from being absent at school, at the crime scene.
I haven't previously testified to that, but I can right now if you'd like me to.
No, I'm saying in your statement. Do you mention anything in your statement that solidly implicates Blair Rollins at the crime scene more than the defendant?
I mean, the cell tower records equally implicate Blair Rollins if we're going to trust them.
The cell tower records that you said are unreliable and inaccurate?
Yes.
Thank you, Your Honor. No further questions.
Thank you. Redirect.
May I have a time check, Your Honor? In that case, I do not have a redirect, Your Honor.
All right. Thank you. And does the defense have any further witnesses?
No, Your Honor. The defense rests its case in chief.
Thank you very much, counsel. And are both sides ready to give their closing arguments?
Yes, Your Honor.
All right.
Yes, Your Honor.
Thank you. The people may proceed with its closing.
Your Honor, before I begin, may I reserve any remaining time for a rebuttal after the defense's closing?
You may.
Thank you. Your Honor, members of the jury, may it please the court. My name is Sydney Dragovich, and I represent the prosecution. A person is more than their worst mistake, but mistakes have consequences. The defendant has made countless mistakes in her life and often dodged the consequences of them. But today, the state asks you to hold her accountable for her biggest mistake, murdering Mackenzie Brackman. The defendant is guilty beyond any reasonable doubt for 3 reasons: incriminating evidence, a thorough investigation, and unreliable defense witnesses. First of all, the evidence incriminates the defendant. Her tumultuous feud with Mr. Brackman, combined with her rashness, resulted in the break-in and then the murder of Mr. Brackman. The ring cameras show the defendant matches the build and size of the intruder. The texts with Alex Fuentes show the defendant's plans to break in. The school records place the defendant as absent that day, and the evidence of a struggle in Mr. Brackman's home show that this murder was not planned by a vengeful ex-client, but a chaotic consequence of the defendant's mistakes. Furthermore, Professor Van Owen only objected to Kuzak's theory about the stabbing because of the reported height difference. However, if Mr. Brackman was engaged in a struggle with someone smaller than him, he would not likely be standing at his full height, and therefore there would be no issue of height difference with the stabbing. Second, the thorough investigation dispels any reasonable doubt. You heard how thorough Detective Markowitz and CSR Kyle Kuzak were, and how they had no pre-existing bias to suspect the defendant. That is simply who their honest investigation led them to. Detective Markowitz's thoroughness, paired with Kuzak's credible CSR techniques, led them to one conclusion: that this was a planned burglary gone bad on behalf of the defendant. Third, the unreliability of the defense witnesses discredits their entire case. You heard how Taylor Perkins willingly and consistently sacrificed for the defendant throughout their whole relationship. Perkins is an unfortunate example of the manipulation that the defendant is capable of, but even well-meaning deceit is deceit all the same and must be treated as such. You also saw how the defendant turned on Alex when Alex told to tell the truth. The defendant tried to manipulate you in court today, members of the jury, but after such a long and relentless feud, it is simply not believable that the defendant would have a sudden change of heart, conveniently when she is charged with murder. You also saw how Blake Van Owen's guilt from her own mistake as a police officer has led her to try to find mistakes on behalf of the police, even where mistakes don't exist. She tried to distract you by talking about Blair Rawlins' supposed motive, when motive isn't an element of either of the crimes in this case, and criticizing Detective Markowitz for not collecting enough of the cell tower records, immediately after telling you how unreliable the cell tower records are. Professor Van Owen ignored the physical evidence at the crime scene, which isn't surprising since she is not and never has been a CSR. Her evidence for Blair Rawlins is inconclusive at best, and all of these inconsistencies reveal Van Owen to be guided by bias so blinding, it destroys any credibility on her behalf. Members of the jury, you heard the defendant say, "I would never do anything else to Brackman." Now, this statement has some truth in it because Mr. Brackman was murdered by the defendant, and no one can do anything to or for him anymore, except make sure that the defendant faces the consequences of her crime. The incriminating evidence, the thorough investigation, and the unreliability of the defense witnesses show the defendant to be guilty beyond any reasonable doubt of first-degree murder and second-degree burglary. The defendant has gotten away with many things in her life, but we hope that you will not allow murder to be one of them. Thank you.
Thank you, counsel. Defense, closing argument, please.
The prosecution told you that mistakes have consequences. Members of the jury, today the defense asks that you don't let the mistakes of the police department have the consequence of an innocent young woman's conviction. A good investigator investigates. They don't take the path of least resistance at the expense of the case. Today, Detective Markowitz told you how crucial it is for an investigator to follow up on all possible leads, a reasonable rule to go by. In this case, however, she chose not to, and it is because of that failing that Avery Becker sits before you today. Almost immediately after arriving on the scene and observing the victim's body, Detective Markowitz recognized the victim, Mackenzie Brackman, a criminal defense attorney. The detective had an immediate realization. It's not uncommon for a criminal defense attorney to be targeted by a disgruntled ex-client. However, Detective Markowitz identified an easier pathway to investigate, one that thrust itself into her lap, one that went through Alex Fuentes. You heard how this very first person that the detective called gave her what she classified as the biggest break in her case. Yet Detective Markowitz did nothing to verify this big break, although it would have been exceedingly easy for her to do so with her special training and the resources of the police department. She never even asked Alex to bring the phone in. The prosecution carries the burden of proof in this case. They must prove to you beyond a reasonable doubt that it was Avery Becker who intruded Mr. Brackman's house and caused his death. This is the highest standard of proof. Yet notice how the prosecution focused on attacking the credibility of our witnesses and our evidence, rather than trying to prove their own. If you, members of the jury, have any reasonable doubt that Avery Becker committed these crimes, if there is any part of the prosecution's case that falls through or any other explanations for what happened on March 6th, you must find Avery Becker not guilty. So what has the prosecution provided for us today in their attempt to reach this high standard of proof? There are two main pieces of evidence that they've used. First, the screenshots that could have easily been faked and that could have easily been verified, yet never were. And second, the call detail records. The call detail records that aren't that accurate to begin with, and that show us that Blair Rowlands, an alternate suspect for the police department, lives in the same area and next to the same cell tower antenna as Avery. Let's look at what Avery was really doing on March 6th. In order to do that, though, first let's talk about March 5th. We learned that Avery and Taylor went to the Fry Shack together. Alex himself told you about how he played a game on Avery's phone that night. Sometime after that, Avery realized that her phone was missing. Alex had Avery's phone, then Avery's phone went missing. Alex was friends with Blair Rowlands, an unlocated suspect. Alex himself was considered a suspect by the police, but then testified against whom he called his best friend. Avery and Taylor testified about the jealousy that Alex showed against Avery. Alex was the last one to have Avery's phone, and the next day, Alex gave Markowitz her biggest break in the case with screenshots that nobody bothered to verify. Avery and Taylor spent March 6th, the day of Mr. Brackman's murder, looking for Avery's phone. This was confirmed by the unanswered calls from Taylor to Avery throughout the day as they tried to locate her phone. Professor Van Owen also investigated this case, and unlike Detective Markowitz, she investigated other leads and followed up on alternate suspects. Her investigation led her to Blair Rowlands, the daughter of one of Mr. Brackman's ex-clients who got convicted. You heard Exhibit 22. I'll get you back, Brackman, if it's the last thing I do. Blair Rowlands heard that. The police department didn't bother to verify the screenshots. They didn't bother to investigate viable alternate suspects. They didn't bother because the moment that Detective Markowitz got her biggest break in the case, from that first call, she decided to take the path of least resistance. You must find Avery Becker not guilty.
Thank you, counsel. All right, this case stands submitted.
Your Honor, may I have time for my rebuttal,
Oh,
please?
I'm sorry, you do have rebuttal.
It's all right.
How much time is there left for rebuttal from the timekeepers? All right, counsel rebuttal.
Thank you. Members of the jury, there were no mistakes on the police's behalf. Just because they competently solved this case in an efficient manner of time, that does not mean that their conclusions are invalid. Furthermore, Alex Fuentes showed incredible honesty and bravery today testifying against one of his friends. And it does not matter that they were screenshots. His integrity and honesty shows that these are valid text messages. Furthermore, we did not rely on the cell towers to prove our case. We relied on the ring cameras, the text messages, the school records, the credible testimonies, and evidence at the crime scene. This all led us to conclude that this was not some vague, our case did not rely on a vague comment made by Mr. Rollins. Our case relied on countless evidence that led us to show and prove to you that Avery Becker is guilty today. In conclusion, We implore you to hold Avery Becker accountable for her crimes, crimes that we have proven her guilty of beyond a reasonable doubt. Thank you.
Thank you, counsel. All right, now this case stands submitted. And I want to thank all of the students and congratulate all of the students for an excellent presentation this afternoon. I want to give my timekeepers an opportunity to do their job. And I just want to tell you folks, you know, when I was a lawyer, I used to love being in the courtroom, and I became a judge because I love being in the courtroom. And this was terrific. If I had any thought at all about inviting you students to come into my courtroom to watch how it's done, I'm going to change that and invite the lawyers in my courtroom to watch you to learn how it's done, because you all were very well prepared. And there were times when I was riveted, especially, I have to say, in that last bit, the cross-examination by Ms. Dragovich of Ms. Lowe. That was very real. And there were a lot of parts of this trial I thought that were very real. There were a lot of unexpected surprises, which always happens, no matter how much the lawyers try to rehearse what's going on in their mind before a trial. There are always surprises. You can't possibly predict everything that's going to happen. Witnesses forgot or got confused about their testimony, even though they'd rehearsed it dozens of times, and that happens virtually every trial. That is perfectly natural, very, very common. And the lawyers get surprised by objections or by something that the witness says. Now, I will tell you that there were some objections that I ruled differently because I wanted the evidence to come in. I don't think there was much that I kept out, if anything. And there were some things that I probably would have kept out at trial, but for purposes of this, because it was really more the learning experience, I wanted to hear objections, and you know the rules. You're very well coached. The responses were good. The objections were good. And I thought everyone did a very, very, very good job. So I congratulate all of the students and all of the coaches and all of the parents. Does anyone have any questions? Well, let me first ask, are my timekeepers ready?
You mean your scorekeepers, Judge?
Sorry, my scorekeepers. Yes.
I just submitted mine. I'm ready.
All right. And Ms. Myers, are you ready as well?
Yes, it just went through.
Okay. Ms. Greer, good evening.
Good evening, Your Honor. Wow, you guys, that was incredible. And you are a very well-matched team. Sometimes you see one team that really overpowers the other. And like Judge Kramer said, that last cross-examination especially, it was really riveting. It looked real. It did. And the closings were great. They weren't rehearsed. They weren't scripted. They went by what the evidence had actually come in and shown. I think everybody did a great job. I hope if this is your first year on the moot court that you have another year, just because the feel of the courtroom is so different, and being in the courtroom and doing it is very, well, Judge Kramer said it, it's kind of a high being in there and doing that. It's something that a lot of trial attorneys just love. And I hope you get the chance to do that before you finish your high school career. But great job.
Thank you, Ms. Greer. Ms. Myers.
Yes, so I echo what everyone else said. You guys were all phenomenal. This is actually my first year and my first round judging a mock trial. So you set the bar high. At times, I think similar to everyone, and I'm absolutely guilty of it too, I get ahead of myself because my thoughts during trial are running so quickly. I tend to talk faster, but you guys did great. I don't really even have that many criticisms apart from, if you need to take a breath sometimes, feel free to, but you guys did great.
Thank you, Ms. Myers. Ms. Henninger, good evening.
Yes, I have to agree with everyone here today. I can't believe these kids are in high school. I wish more attorneys were as good as they are. I agree with you, Judge, that maybe a lot of the attorneys need to take lessons from them. I wish I had something like this in my high school. I was not offered anything like this. You guys are 20 steps ahead of everybody else that is going to walk into law school. And you're not even there yet. You still have to get your undergrad. So I think, I mean, I'm even impressed on the rules of evidence that you all knew. There's so many attorneys. I practice family law. And I can say, you know, it's always crazy to me how many attorneys don't really know the rules of evidence. It's one of the hardest things to learn in law school. Again, you guys are so many steps ahead, but I think that's going to be your key class if you do go to law school. I don't really have that many criticisms either. I think everyone did an excellent job. I can say I thought the defense did a really good job with keeping their theme. I followed the theme all the way through the trial, you know, starting with the opening statement all the way to the closing statement. And I thought that was good. I think that really helps especially if you are going to do criminal law and you're going to have juries, I think that's going to help you keep the jurors' attention. I think witness control is one of the hardest things still for me. I mean, I've been practicing about 5 years now, and I still find that to be one of the most difficult things in the courtroom. And it was interesting to see how each of you did that differently today when you were cross-examining the witnesses. I know that's really hard, but I thought Sydney and Robin did a really good job with that, kind of keeping their witness under control there. And then I guess my only other comment is, maybe some of you working on like your transitioning statements. I also thought Robin did a really good job with that. Because I know sometimes that's hard. And I think that's where some of you today had to back up to lay the foundation for some of your things. I think those transitioning statements kind of help that, you know, like, okay, now let's turn your attention to this date or this event, and then, you know, kind of start to lay your foundation to get into that next topic. I think that also helps your audience kind of stay on track with you. But yeah, that's really all I have. I thought everyone did excellent.
One last thing I'll say, and then I'm going to invite all the students who wish to turn on your cameras. And if you have any questions that you'd like any of the attorneys or me to answer for you, I'm sure we'll be happy to stick around. One other thing I wanted to say was I was actually really glad that there was the problem with the exhibits, sharing the exhibits. And I think Ms. Kite, maybe that was you who that happened during your presentation. That's just a classic unexpected problem that you confront during trial that you can't possibly anticipate. And I got to say, you folks, you figured it out and you moved on, and the trial proceeded as if it never happened. And that's exactly the right way to proceed. You handled it, every one of you handled it the right way. The team came together, somebody figured it out, and the trial went on. So congratulations and thanks for that. Okay, does anyone have any questions? Go ahead and turn your cameras on if you want. Good job.
I would just like to thank you, Your Honor, and the judges for their time. This means so much. Thank you.
Well, it was fun for me.
Yeah, me too. I wish every Friday I could do this every Friday afternoon.
I would like to thank everyone as well, because I understand it's Friday night and it's almost 7 o'clock, but I want to thank everyone, including the opposing team, for being here, because this was such a fun and amazing experience to have.
Does anyone have any questions? All right. Well, go about the rest of your evening, and I wish all of you good luck in rounds 3 and 4. All right. Good night.
And have
all.
fun.
Yes.
Have fun tomorrow.
Have fun.
Yeah, for sure.
I could tell though, you guys were really getting into it today. You were definitely in your roles as attorneys or witnesses. For sure you were. And that's good. But Ms. Greer's right. Have fun tomorrow.
Thank you so much.
Yeah, I
Thank
also wanted to second and thank you because this, I love mock trials so much. And it's my senior year, and it's kind of hard having to do this online, but I'm still so happy that we figured it out and that you guys are doing this because it means a lot. So thank you.
Thank you all. And thanks to all the coaches and parents out there for all of your coaching and support for these students. All right. Good night, everyone.
All right.
Oh, hold on. You
Bye.
know what? I think we need to wait a minute before everybody goes. I think I need to hear from our monitor before I can let everybody go.
Your Honor, I think you can let everyone go. We've accomplished everything we need to. Thank you, everyone, for your participation. We have all of the scoring sheets, so I will see everyone tomorrow.